morning, my dear students. I am Subramaniam, Department of Social Science. I am going to take the topic Civics, Unit 1, Lesson Indian Constitution. In the last class, we learnt about the need for Constitution, making of Indian Constitution, salient features of Indian Constitution, preamble, citizenship. Now we discuss about fundamental rights, right to constitutional remedies, habeas corpus, mandamus, prohibition, certiorari, quo warranto, suspension of fundamental rights, difference between fundamental rights and directive principles of state policy, right to equality, right to freedom, right against exploitation, right to religion, cultural educational rights, fundamental rights. Okay, students, the fundamental rights are enshrined in part 3rd of the constitutional. The fundamental rights are enshrined in part 3rd of the constitution from articles 12 to 35. In this regard, the framers of the constitution derived inspiration from the constitution of USA. I mean, the fundamental rights derived from the USA. Originally, the constitution provided for 7 fundamental rights. Originally, the constitution provided for 7 fundamental rights. At present, there are only 6 fundamental rights. At present, there are only 6 fundamental rights. Part 3 of the Constitution is rightly described as the Magna Carta of India, which is called the Magna Carta of India. The Part 3 of the Constitution. Part 3 of the Constitution is rightly described as the Magna Carta of India, which is called Magna Carta of India. Part 3 of the Constitution. While fundamental rights are available to all persons, fundamental rights are available to all persons, certain fundamental rights are available only to Indian citizens. Certain fundamental rights are available only to Indian citizens. Okay, students, next heading, right to constitutional remedies. A writ is an order or command issued by a court in writing under a seal. The writ is a order, the command issued by a court in writing under its seal. It is in the nature of command or prohibition from performing certain acts. I mean, the writ is a nature of command or prohibition from performing certain acts that are specified in the orders of the court. It is specified in the orders of the court. Both Supreme Court and the High Court, Supreme Court and the High Court are empowered to issue the 5 kinds of writs. Which organs have the empowered 5 kinds of writs? The High Court and Supreme Court have the empowered to issue 5 kinds of writs. That is why the Supreme Court is called the guardian of the Constitution. Which is called guardian of the Constitution? The Supreme Court is called guardian of the Constitution. According to the Dr. Ambedkar, Article 32 is the heart and soul of the Constitution. Which is called heart and soul of the Constitution? Article 32. Article 32 is the heart and soul of the Constitution. Habeas corpus. What is meant by habeas corpus? The safeguard people from illegal arrest. This order issued Supreme Court or High Court. Okay, students, next mandamus. It protects the the petitioner who requires legal help to get his work done by the respective public authorities. I mean, mandamus means it protects the petitioners who requires legal help to get his work done by respective public authorities. Prohibition. It prohibits a subordinate court from acting beyond its jurisdiction. It prohibits a subordinate court from acting beyond its jurisdiction. Certiorari. This order issued for causes an order issued by an subordinate court by overstepping its jurisdiction. This order issues for cause an order issued by an subordinate court by overstepping its jurisdiction. Quo warranto. The quo warranto, it prevents the usurpation of public office through illegal manner. The quo warranto issued for prevent usurpation of public office through illegal manner. Okay students, next, suspension of fundamental rights. When the president makes a proclamation of emergency, when the president make a proclamation of emergency under Article 352, the freedoms guaranteed under Articles 19 are automatically suspended. When did the fundamental rights automatically suspended? When the president make a proclamation of emergency under Article 352, the freedom guaranteed under the Articles 19 are automatically suspended. When did the fundamental rights automatically suspended? When the president make a proclamation of emergency. Okay students, the president can suspend other fundamental rights through the specific order. The president can be suspended the other fundamental rights through specific orders. These orders must be approved by the parliament. These orders must be approved by the parliament. Okay students, next one, the difference between fundamental rights and directive principles of the state policy. Fundamental rights and directive principles. Fundamental rights. Fundamental rights was derived from the Constitution of USA. Fundamental rights derived from the Constitution of USA. And the directive principles derived from the Constitution of Ireland. Fundamental rights. Even the government cannot take away or bridge these rights. Even the government cannot take away or abridge these rights. These are the enforceable by the court law. The fundamental rights are enforceable by a court law. The fundamental rights have legal sanction. The fundamental rights strengthen the political democracy in the country. The fundamental rights strengthen the political democracy in the country. Directive principles of the state policy. The directive principles of the state policy, it was drawn on the model of the Constitution of Ireland. These are mere instruction to the government. These are mere instruction to the government. These are not enforceable in any court. Directive principles are not enforceable in any court. These have moral and political sanction. Directive principles are moral and political sanction. This implementation of these principles ensure the social and economic democracy. The directive principles are implementation of these principles ensure social and economic democracy. Right to equality. Six fundamental rights are 6. They are, first one, right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to constitutional remedies. Okay students, first one, right to equality. Articles 14, the equality before law. Articles 14 says the equality before law. Articles 15, prohibition of discrimination on grounds of religion, race, caste, sex or place of the birth. Article 16, equality of opportunity in matters of public employment. Equality of opportunity in matters of public employment. And Article 17, abolition of untouchability. Article 17, abolition of untouchability. Article 18, abolition of titles except military and academic. Okay students, next one, right to freedom. The freedom of Article 19, the freedom of speech and expression, assembly, association, movement and residence and professions. Article 22 Article 20 allowed the protection in respect of the conviction for offences. The protection in respect of the conviction for offences. Article 21, protection of life and personal liberty. Protection of life and personal liberty. Article 21A, right to elementary education. Right to elementary education. Act 22, the protection against arrest and the detention in certain cases. Okay students, next one, right against exploitation. Article 23, prohibition of traffic in human beings and forced labor. The prohibition of traffic in human beings and forced labor. Article 24, prohibition of employment of children in factories, etc. Prohibition of employment of children in factories, etc. Right to religion. Next one, right to religion. The freedom of the conscience and free professions and practice and propagation of religion. The freedom of the conscience and free profession, practice and propagation of religion. Article 26, freedom to manage religious affairs. Freedom to manage religious affairs. Article 27, freedom from payment of taxes for promotion of any religion. Freedom from payment of taxes for promotion of any religion. Article 28, the freedom from attending religion instruction. Freedom from attending religious instructions or worship in certain educational institution. Worship in certain educational instruction. Next reading, the cultural and educational rights. Article 29, protection of language and script and cultural of minorities. Protection of language, script and culture of minorities. Article 33, right of minorities to establish and administer educational institution. Right to minorities to establish and administer educational institutions. Next one, right to the constitutional remedies. Article 32, allow the individuals to seek redressal for the violation of their fundamental rights. Article 32 allows individuals to seek redressal for the violation of the fundamental rights. Okay students, next one, directive principles of state policy. Directive principles of state policy. The directive principles of state policy are enumerated in Part 4 of the Constitution, from Articles 36 to 51. The directive principles of state policy are enumerated in Part 4 of the Constitution from Articles 36 to 51. The Constitution does not contain any classification of directive principles. The Constitution does not contain any classification of directive principles. However, on the basis of their content and directions, they can be classified into three broad categories. On the basis of their content and directions, they can be classified into three broad categories: socialistic, Gandhian, and liberal intellectuals. These principles are not enforceable by the courts. Which principles are not enforceable by the courts? I mean, the socialistic, Gandhian, and liberal intellectuals are not enforceable by the courts. Okay, next one. But they are fundamental for the government of the country. But they are fundamentals for the governance of the country. They aim to promoting the social welfare of the people. Directive principles aim at promoting the social welfare of the people. Dr. Ambedkar described these principles as novel features of the Indian Constitution. Dr. Ambedkar described these principles as novel features of the Indian Constitution. The 86th Amendment Act of 2002 changed the subject matters of Article 45. The 86th Amendment Act of 2002 changed the subject matter of Article 45 and made elementary education a fundamental right. Elementary education a fundamental right. Article 45 made elementary education a fundamental right. Under Article 21A, the amendment directive requires the state to provide early childhood care. The amended directive requires the state to provide early childhood care and education for all children until they complete the age of 6 years. The amended directive requires the state provide early childhood care and education for all children until they complete the age of 6 years. Okay students, the important points of this topic. First one, fundamental rights. The fundamental rights are derived from the USA. At present, there are only 6 fundamental rights. Next, the right to the constitutional remedies. A writ is an order or command issued by a court in writing under its seal. Next one, the suspension of the fundamental rights. When the President makes a proclamation of emergency, when the President makes a proclamation of emergency, the freedom of guaranteed under the Article 19 are automatically suspended. When did the fundamental rights are automatically suspended? When the President makes proclamation of emergency. Okay students, next one, the 6 fundamental rights. How many rights are in the 6 fundamental rights? They are right to equality, right to freedom, right against exploitation, right to religion, cultural and educational rights, right to constitutional remedies. Okay students, thank you for watching.